CLJ 400 final exam. Question number 1. Define evidence and its scope. Revise rules on evidence. Rule 128, Section 1. Evidence defined. Evidence is the means sanctioned by these rules or of ascertaining in the judicial proceeding the truth respecting a matter of fact. Revise rule. The rules scope. The rules of evidence shall be the same in all courts and all trials and hearings except as otherwise provided by law or these rules. Number 2. What are the three kinds of evidence? Briefly explain each. So, object as evidence. Object as evidence are those addressed to the sense of the court. When an object is relevant to the fact in issue, it may be exhibited to examine or viewed by the court. Documentary evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, number, figures, symbols of their equivalent or other modes of written expression offered as proof of their content. Testimony confined to be personal knowledge. Witness can testify only to those facts which he or she knows of his or her personal knowledge. Number 3. Distinguish corroborative evidence from cumulative evidence. So, corroborative evidence is additional evidence of different kind and character tending to prove the same point. Meanwhile, cumulative evidence is the additional evidence of the same kind and character tending to prove the same point. This is purely the accumulation of similar evidence that is derived from common sources. Number 4. What is prima facie evidence? Prima facie evidence is the evidence which is, if unexplained or uncontradicted, is sufficient to sustain a judgment in favor of the issue it supports. Number 5. What is dying declaration? Dying declaration, the declaration of the dying person made under the consciousness of an impending death may be received in any case wherein his death is the subject of inquiry as evidence of the cause surrounding circumstances of such death. Number 6. What about statements uttered as a part of the res gestae? So, part of the res gestae, statements made by a person while a startling occurrence of taking place or immediately prior or subsequent thereto. Number 7. What is order of examination of individual witnesses? Briefly define each. So, revised rules on evidence, Rule 132, A, Section 4, the order of examination of individual witnesses. The order as follows: A. Direct examination by the proponent. B. Cross-examination by the opponent. Redirect examination by proponent. And re-cross-examination by the opponent. So, direct examination is the examination in chief of a witness by the party presenting him or her in the facts relevant to the issue. Cross-examination is so its purpose and extent upon the determination of direct examination. The witness may be cross-examined by the adverse party on any relevant matter with sufficient fullness and freedom to test his or her accuracy and truthfulness and freedom from interest or bias or the reverse to elicit all important facts bearing upon the issue. Redirect examination, its purpose and extent after the cross-examination of the witness has been concluded, he or she may be re-examined by the party calling him or her to explain or supplement his or her answers given during the cross-examination. So, re-cross-examination. Upon the conclusion of redirect examination, the adverse party may re-cross-examine the witness on matters stated his or her redirect examination, also such on vice matters as may be allowed the court in its discretion. Recalling witness. After the examination of a witness by both sides has been concluded, the witness may be recalled without the leave of the court. The court will grant or withhold leave in its discretion as the interests of justice may require. Number 8. Briefly explain what is judicial affidavit rule. So, judicial affidavit rule took effect on January 1, 2013. A normal court proceeding will take around 3 or 5, even more years to fully decided. By requiring the submission of affidavits of witnesses through the jar, the time of concluding a court proceeding will be shortened. Number 9. An offer or compromise in criminal cases is an implied admission of guilt. What are the two exemptions? There are only two exceptions with compromise is not admissible as an implied admission of guilt in criminal cases. One is in a quasi-offenses are defined and penalized under Articles 365 of the Revised Penal Code. And 2 is those allowed by law to be compromised. Number 10, in order to evidence to be admissible, it must be relevant and competent. Which, when evidence is relevant, when is evidence competent? So, relevance under Rule 128, Section 4, evidence is relevant if it has a relation to the fact in issue as to induce belief in its existence or non-existence. From this rule, we gather that there are two components of relevance. First, relevance evidence is relation to the fact in issue. If there is a relationship between the evidence and the fact in issue, then the evidence is material. Second, relevance evidence can lead us to believe in the existence or non-existence of fact in issue. If the evidence supports our belief that the alleged fact exists, then the evidence has probative value. Competence, in addition to relevance, admissible evidence must also be competent. Under Rule 128, Section 3, evidence is competent if it is not excluded by law or these rules. If a piece of evidence is disqualified. Number 11, what is a leading question? When is it allowed? So, leading and misleading questions. A question which suggests to the witness the answer which the examining parties desires is a leading question. It is not allowed when, except on cross-examination, be on preliminary matters. C, when there is difficulty in getting direct and intelligible answer from a witness who is ignorant, a child of a tender years, is feeble mind, or a mute. D, of an unwilling hostile witness, or of a witness who is adverse party, or an officer, director, or managing agent of a public-private corporation of a partnership. 12. What is misleading question? A misleading question is one which assumes as through a fact not yet testified by the witness or contrary to that which he or she has previously stated. It is not allowed. So, when is circumstantial evidence sufficient to sustain a conviction? Circumstantial evidence when sufficient for conviction if there is more than one circumstance, the facts from which the inferences are derived are proven, and the combination of all the circumstances is such as to produce a conviction beyond reasonable doubt. 14. Distinguish burden of proof from burden of evidence. Burden of proof and burden of evidence. Burden of proof is a duty of a party to present evidence on the facts in issue necessary to establish his or her claim by defense of by the amount of evidence required by law. Burden of proof never shifts. Burden evidence is the duty of a party to present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. Burden evidence may shift from one party to the other in the course of the proceedings, depending on the exigencies of the case. 15. What is the standard of proof necessary in civil cases? Criminal cases, administrative cases. Substantial evidence is the quantum of proof required by law. 16. Define what are public documents. A. The written official acts are the record of the sovereign authority. Documents acknowledged by non-notary public, except last wills and testaments. Documents that are considered public documents under theatres and conventions which are forced between the Philippines and the country. 4. How do you prove present by anyone who saw the document executed or written by evidence of the genuineness of the signature hand. 18. Any problem is identified as the original document stated. Original documents must be produce exceptions. Number 9, who can become a witness? So, qualification of a witness. Section 20, witnesses there except as provided in the next succeeding section. All persons who can perceive and perceiving can make their known perception to others may be witnesses. Number 20, when is an extrajudicial confession sufficient to sustain a conviction? Section 3, extrajudicial confession not sufficient for ground for conviction. An extrajudicial confession made by an accused shall not be sufficient ground for a conviction unless corroborated by evidence of corpus delicti.